Okay, we're going live. Talking about Miranda for the next 20 pages. Do or die. Recall the dissenting in 1944 Ashcroft case. Justice Jackson agreed that the detention and questioning of a suspect for 36 hours is inherently coercive, but quickly added, so is custody and examination for 1 hour. Arrest itself is inherently coercive, and so is detention. But does the Constitution prohibit the use of all confessions made after arrest because questioning while one is deprived of freedom is inherently coercive? Both Jackson and Justice Black, who wrote the majority opinion in Ashcroft, knew that in 1944 the court was not ready for an affirmative answer to Jackson's question. But by 1966, the court had grown ready. Yes, answered 5-4 majority in Miranda versus Arizona. The Constitution does prohibit the use of all confessions obtained by in-custody questioning unless adequate protective devices are used to dispel the coercion inherent in such questioning. The protective devices deemed necessary to neutralize the compulsion inherent in the interrogation environment unless the government adopts other equally effective means, and what they may be remains unclear, are the now familiar Miranda warnings. Ah, nice sentence. The Miranda court's reasoning, if not its result, surprised the late John J. Flynn, Miranda's lawyer, in the U.S. Supreme Court. As Flynn later recalled, he and others working on the case had agreed that the briefs should be written with the entire focus on the Sixth Amendment right to counsel, because that is where the court was headed after Escobedo. But in the very first paragraph of the Miranda opinion, the Chief Justice Warren said, in effect, it is the Fifth Amendment privilege against compulsory self-incrimination that is at issue today. That was Miranda's effective use of counsel. Although not happy with the continued momentum of the Warren court in favor of the rights of suspects, those alarmed by Messiah and Escobedo must have found some comfort in the Miranda court's switch in emphasis from the right to counsel to the privilege against compelled self-incrimination. Recall that the Escobedo dissenters expressed in preference for the self-incrimination approach rather than the right to counsel approach, because the self-incrimination clause prescribes only compelled statements. Of course, before Escobedo dissenters, all of whom dissented in Miranda, were not pleased with the way the Miranda majority defined compulsion within the meaning of privilege. All right, so that's going to be something to look for. What is compulsion? Why in the 30 years between Brown versus Mississippi in 1936 and the first 14th Amendment due process case, Miranda had the Fifth Amendment's ban against compelling a person in any criminal case to be a witness against himself been so neglected in the confession cases. For one thing, this prohibition had not been deemed applicable to the states until 1964, and by that time a large body of law pertaining to involuntary and coerced confessions had developed. And more important, the prevailing pre-Miranda view was that compulsion to testify meant legal compulsion. Since the suspect is threatened either with perjury for, this is all legislative history, I guess, or actually not even, like procedural history. Since the suspect is threatened neither with perjury for testifying falsely nor contempt for refusing to testify at all, it cannot be said, ran with the argument that a person undergoing police interrogation is being compelled to be a witness against himself within the meaning of the privilege, even though under such circumstances a person may assume to be led to believe that there are legal or extra-legal sanctions for refusing to cooperate. Since the police have no legal right to make a suspect answer, although prior to Miranda the police did not have to tell a person that there was no legal obligation to answer, ran the argument to which a privilege in technical sense could apply. Although the right to counsel had dominated the confession scene in the years immediately preceding Miranda. There was some reason to think that, at long last, the self-incrimination clause might move to center stage. In Malloy v. Hogan, 1964, which did not involve a confession, the court per Brennan performed what some call a shotgun wedding of the privilege against self-incrimination to the confession clause applicable to the states, but declared that whenever a question arises in a state or federal court, whether a confession is incompetent because not voluntary, the issue is controlled by the self-incrimination portion of the Fifth Amendment. Whether or not this view made good sense, it constituted very questionable recent history. In none of the dozens of state or federal confession cases decided in the 1930s, 40s, or 50s had the self-incrimination clause been the basis for judgment, although it had occasionally been mentioned in an opinion. But now the Malloy opinion looked back was not as important as how it looked forward. The confession rules and the privilege against self-incrimination had become intertwined in Malloy, and they would be fused in Miranda. So, Miranda versus Arizona. So they are number 759 star, and that means in the footnote says together with number 760 Vignera versus New York, and number 761 Westover versus United States, and number 584 California versus Stewart. Still don't know what that means, but Chief Justice Warren delivered the opinion of the court in 1966. The cases before us raise questions which go to the roots of American criminal jurisprudence. The restraints on society must observe consistent with the federal constitution in prosecuting individuals for crime. More specifically, we deal with the admissibility of statements obtained from an individual who is subject to custodial police interrogation and necessity for procedures which assure the individual is accorded his privilege under the Fifth Amendment to the Constitution not to be compelled to incriminate himself. We start here, as we did in Escobedo, with the premise that our holding is not an innovation in our jurisprudence, but is an applicable principle long recognized and applied in other settings. We have undertaken a thorough re-examination of the Escobedo decision and the principles it announced and reaffirm it. That case was but an explication of basic rights that are enshrined in our Constitution, that no person, shall be compelled in any criminal case to be a witness against himself, which are put in jeopardy in that case through official overbearing. Now, our holding will be spelled out with some specificity in the pages which follow, but briefly stated as that it is this. The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. As for the procedural safeguards to be employed, unless the fully effective means are devised to inform the accused persons of their right of silence and to ensure continuous opportunity to exercise it, the following measures are required. Prior to any questioning, a person must be warned that he has the right to remain silent and that any statement he does make may be used as evidence against him, and then he has the right to the presence of an attorney, either retained or appointed. The defendant may waive effectuation of these rights, provided the waiver is made voluntarily, knowingly, and intelligently. If, however, he indicates in a manner and in any stage of the process that he wishes to consult with an attorney before speaking, there can be no questioning. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police may not question him. The mere fact that he may have answered some questions or volunteered some statements on his own does not deprive him of the right to refrain from answering any further inquiries until he has consulted with an attorney and thereafter consents to be questioned. The constitutional issue we decide in each of these cases is the admissibility of statements obtained from the defendant questioned while in custody and deprived of his freedom in any significant way. In each, the defendant was questioned by police officers, detectives, or prosecuting attorney. In a room in which he was cut off from the outside world. In none of these cases was the defendant given a full and effective warning of his rights at the outset of the interrogation process. In all the cases, the questioning elicited oral admissions, and in 3 of them, signed statements as well, which were admitted at their trials. They all thus share silent features in communicado interrogation of individuals. In a police-dominated atmosphere, resulting in self-incriminating statements without full warnings of constitutional rights. Again, we stress that the modern practice of in-custody interrogation is psychologically rather than physically oriented. Interrogation still takes place in privacy. Privacy results in secrecy, and this in turn results in a gap in our knowledge as to what in fact goes on in interrogation rooms. A valuable source of information about present police practices, however, may be found in various police manuals and texts which document procedures employed with success in the past, which recommend various other effective tactics. These texts are used by law enforcement agencies themselves as guides. It should be noted that these texts professedly present the most enlightened and effective means presently used to obtain statements through custodial interrogation. By considering these texts and other data, it is possible to describe procedures observed and noted around the country. So interrogation strategy is written here in the margin. To highlight the isolation and unfamiliar surroundings, the manuals instruct the police to display an air of confidence in the suspect's guilt and from outward appearance to maintain only an interest in confirming certain details. The guilt of the subject is to be posited as a fact. The interrogator should direct his comments toward the reasons why the subject committed the act rather than court failure by asking the subject whether he did it. Like other men, perhaps the subject has had a bad family life and an unhappy childhood, had too much to drink, had an unrequited desire for women. Officers are instructed to minimize the moral seriousness of the offense, to cast blame on the victim or on society. These tactics are designed to put the subject in a psychological state where his story is but an elaboration of what the police purport to know already, that he is guilty. Explanations to the contrary are dismissed and discouraged. So we're talking psychological circumstances. The text thus stressed that the major qualities an interrogator should possess are patience and perseverance. When other techniques prove unavailing, the text recommend may be altered with the show of some hostility. One ploy often has been termed the friendly unfriendly or mutt and chef act. In this technique, 2 agents are employed: Mutt, the relentless investigator who knows The subject is guilty and is not going to waste any time. He's sent a dozen men away for this crime, and he's going to send the subject away for the full term. Jeff, on the other hand, is obviously a kind-hearted man. He has a family himself. He has a brother who was involved in a little scrape like this. He disapproves of Mutt and tactics and will arrange to get him off the case if the subject will cooperate. He can't hold Mutt off for very long. The subject would be wise to make a quick decision. The technique is applied by having both investigators present while Mutt acts out his role. Jeff may stand by quietly and demur at some of Mutt's tactics while Jeff makes his plea for cooperation. Mutt is not present in the room. The interrogators sometimes are instructed to induce the confession out of trickery. The technique here is quite effective. So here's Mutt and Jeff act. Okay, so here's one tactic, 2, 3, trickery. I want to read the footnotes now. The methods described in Inbow and Reed, Criminal Investigation, Interrogation, and Confessions, 1962, are a revision and enlargement of material presented in the 3 prior editions of a predecessor text, Lie Detection and Criminal Interrogation. The authors and their associates are experienced in writing, lecturing, and speaking to law enforcement authorities over a 20-year period. They say that the techniques portrayed in their manuals reflect the experiences that are most effective psychological stratagem to employ during interrogations. Similarly, the techniques described in O'Hara, Fundamentals of Criminal Investigation, were gleaned from long texts, service as observer, lecturer, and police science, and work as federal criminal investigator. All these texts have had rather extensive use among law enforcement agencies and among students of police science, with total sales and circulation of 44,000. Trickery. The technique here, or which run in series. In the identification situation, the interrogator may take a break in his questioning to place a subject among a group of men in a lineup. The witness or complainant, obviously coached if necessary, studies a lineup and confidently points out the subject as the guilty party. When the questioning resumes, as though there were now no doubt about the guilt of the subject, a variation on this technique is called the reverse lineup. The accused is placed in a lineup, but this time he is identified by several fictitious witnesses or victims who associate him with different offenses. It is expected that the subject will become desperate and confess to the offense under investigation in order to escape from false accusations. The manuals also contain instructions for police on how to handle the individual who refuses to discuss the matter entirely or who asks for an attorney or relatives. The examiner is to concede him the right to remain silent. This usually has a very undermining effect. First of all, he is disappointed in his expectation of the unfavorable reaction on the part of the interrogator. Secondly, a consensus of the suspect's refusal to talk. Incriminating significant. Okay, so this is a response to refusal. Use the word psychological conditioning. Okay, from these representative samples of interrogation techniques, that's probably number 4, I guess. The setting prescribed by the manuals and observed in practice becomes clear. In essence, it is this: to be alone with the subject is essential to prevent distraction and to deprive him of any outside support. The aura of confidence in his guilt undermines his will to resist. He merely confirms the preconceived story the police seek to have him describe. Patience and persistence, at times relentless questioning, are employed. To obtain a confession, the interrogator must patiently maneuver himself or his quarry into a position from which the desired object may be attained. When normal procedures fail to produce the needed result, the police may resort to deceptive stratagems, such as giving false legal advice. It is important to keep the subject off balance, for example, by trading his insecurity about himself or his surroundings. The police then persuade, trick, or cajole him out of exercising his constitutional rights. Even without employing brutality, the third degree or the specific stratagems described above The very fact of custodial interrogation exacts a heavy toll on individual liberty and trades on the weaknesses of individuals. So there's like a lot going on here. False legal advice, trading on his insecurity about himself. Next page. Well, there's a ... there, and we'll go to the next page. In the cases before us today, given this background, we concern ourselves primarily with this interrogation atmosphere and the evils it can bring. In Miranda v. Arizona, the police arrested the defendant and took him to a special interrogation room where they secured a confession. In Vignera v. New York, the defendant made oral admissions to the police after interrogation in the afternoon and then signed an inculpatory statement upon being questioned by an assistant district attorney later the same evening. In Westover v. United States, the defendant was handed over to the FBI by local authorities after they had detained and interrogated him for a lengthy period, both at night and the following morning. After some 2 hours of questioning, federal officers had obtained signed statements from the defendant. Lastly, in California v. Stewart, the local police held the defendant 5 days in the station and interrogated him on 9 separate occasions before they secured his inculpatory statement. Okay, so these are all the material facts of the cases that this is being applied to. In these cases, we might not find the defendant's statements to have been involuntary in traditional terms, or concern for adequate safeguards to protect precious Fifth Amendment rights is, of course, not lessened in the slightest. In each of the cases, the defendant was thrust into an unfamiliar atmosphere and run through menacing police interrogation procedures. The potentiality for compulsion is forcefully apparent. For example, in Miranda, where the indigent Mexican defendant was a seriously disturbed individual with pronounced sexual fantasies, and in Stewart, in which the defendant was an indigent Los Angeles Negro who had dropped out of school in 6th grade. To be sure, the records do not invite overt physical coercion or patented psychological ploys. The fact remains that in none of these cases did the officers undertake to afford appropriate safeguards at the outset of the interrogation to ensure the statements were truly the product of free choice. So why did they say one was Mexican and one was black? I'm wondering if they're trying to muster up some equal protection clause. Substantiation, but I'm not sure if I was going to go any further. It is obvious that such an interrogation environment is created for no purpose other than to subjugate the individual to the will of his examiner. The atmosphere carries with its own badge of intimidation. To be sure, this is not a physical intimidation, but it is equally destructive of human dignity. The current practice of incommunicado interrogation is at odds with our nation's most cherished principles that the individual may not be compelled to incriminate himself unless adequate protective devices are employed. Started on page 2. No statement obtained from the defendant can truly be the product of his free choice. From the foregoing, we can readily perceive an immediate connection between the privilege against self-incrimination and the police custodial questioning. It is fitting to turn to history and precedent underlying the self-incrimination clause to determine its applicability in this situation. Or historical cases. We may view the historical development of the privilege as one which groped for the proper scope of governmental power over the citizen as a noble principle often transcends its origins. The principle has come rightfully to be recognized in part as an individual substantive right to a private enclave where he may lead a private life. That right is a hallmark of our democracy. We have recently noted that the privilege against self-incrimination, the essential mainstay of our adversary system, is founded on a complex of values. All these policies point to one overriding thought: the constitutional foundation underlying the privilege is the respect a government, state or federal, must accord to the dignity and integrity of its citizens. To maintain a fair state and individual balance, quoted from it, to require the government to shoulder the entire load. 8 Wigmore evidence, quoted in McNaughton Revision 1961, page 371, to respect the inviolability of the human personality. Our accusatory system of criminal justice demands that the government seeking to punish an individual produce the evidence against him by his own independent labors rather than by the cruel, simple expedient of compelling it from his own mouth. In sum, the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own will. Quoting Malloy versus Hogan. So this is actually more of like a historic history lesson. Satisfied that all the principles embodied in the privilege apply to the informal compulsion exerted by law enforcement on antagonistic forces and subjected to the techniques of the compulsion to speak in the isolated setting of the police station may well be graded in courts or other official investigations where there are. Because of the adoption by Congress of Rule 5 of the Federal Rules of Criminal Procedure, and this court's effectuation of McNabb versus United States in 1943 and Mallory versus United States in 1957, we have had little occasion in the past quarter century to reach the constitutional issues in dealing with federal interrogations. The supervisory rules requiring protection of an arrested person before without unnecessary delay and excluding evidence obtained in default in that statutory obligation were nonetheless responsive to the same considerations of Fifth Amendment policy that unavoidably face us now as to the states. In the McNabb and Mallory cases, we recognize both the dangers of interrogation and the appropriateness of prophylaxis stemming from the very fact of interrogation itself. Our decision in Malloy versus Hogan necessitates an examination of the scope of our privilege in state cases as well. In Malloy, we squarely held the privilege applicable to the states and held that the substantive standards underlying the privilege applied with full force to state court proceedings. The reason in Malloy made clear what had already become apparent, that the substantive and procedural safeguards surrounding admissibility of confessions in state cases had become exceedingly exacting, reflecting all the policies embedded in the privilege. The voluntariness doctrine in the state cases, as Malloy indicates, encompasses all interrogation practices which are likely to exert such pressure upon an individual as to disable him from making a free and rational choice. The implications of this proposition were elaborated in our decision in Escobedo a week after Malloy applied the privilege to the states. Our decision today does not indicate in any manner, of course, that these rules can be disregarded. When federal officials arrest an individual, they must, as always, comply with the dictates of the congressional legislation in cases thereunder. In Escobedo, as in the cases today, we saw as protective device to dispel the compelling atmosphere of the interrogation. In Escobedo, however, rather made his later statements the production of this compulsion. The denial of the defendant's request for his attorney thus undermined his ability to exercise or to speak without any intimidation, blatant or subtle. The presence of counsel in all the cases before us today would be conformed to the dictates of the privilege. His presence would ensure that statements made in the government-established atmosphere are not the product of compulsion. Today, then, there can be no doubt that the Fifth Amendment privileges and serves to protect persons in all settings in which their freedom of action is curtailed from being compelled to incriminate themselves. We have concluded that without proper safeguards, the process of in-custody interrogation of persons suspected or accused of crime contains inherently compelling pressures which work to undermine the individual's will to resist and to compel him to speak where he would not otherwise do so freely. In order to combat these pressures and to permit the full opportunity to exercise the privilege against self-incrimination, the accused must be adequately and effectively apprised of his rights, and the exercise of those rights must be fully honored. It is impossible for us to privilege which might be divided by Congress or the states in the exercise of their creative rulemaking capacities. Therefore, we cannot say that the Constitution necessarily interrogation process as it is presently conducted. Our decision in no way creates a constitutional straitjacket which will handicap sound efforts at reform, nor is it intended to have this effect. We encourage Congress and the states to continue their laudable search for increasingly effective ways of protecting the rights of the individual while promoting efficient enforcement of our criminal laws. However, unless we are shown other procedures which are at least as effective in apprising accused persons of their right of silence and in assuring a continuous opportunity to exercise it, the following safeguards must be observed. At the outset, if a person in custody is to be subjected to interrogation, he must first be informed in clear and unequivocal terms that he has the right to remain silent. For those unaware of the privilege, the warning is needed simply to make them aware of it. The threshold requirement for an intelligent decision as to its exercise. Most important, such a warning is an absolute prerequisite in overcoming not just the subnormal or woefully ignorant who succumb to the interrogator's imprecations, whether implied or expressly stated that the interrogations will continue until a confession is obtained. Is itself damning and will bode ill when presented to a jurisdiction. This action constitutes a violation of the Sixth Amendment right to the assistance of counsel and excludes any statement obtained in its wake. See People v. Donovan. Adequate warning as to the availability of the privilege so simple. Pause to inquire if the defendant possessed based on information as to his age, education, intelligence, and prior contact with authorities can never be more than speculation.